Last thing I want to say on Congress is, if Congress is going to preempt claims by individuals who have been seriously harmed, somebody has to pay the costs. I'm not an economist, but I understand that costs don't evaporate just because the law says that you can't recover. So if we're going to put these costs onto somebody, if it's not going to be the manufacturer, then somebody else has to absorb it, and Congress is much more likely to get its preemption views honored if, in fact, it provides for some kind of alternative compensation system. All right, second, what should the agencies do? I assume that agencies have the power, at least in some cases, and I agree with Catherine Sharkey, who's going to come on in a minute, regarding the rules and procedures and their attempts to do categorical preemption. Preambles are out, they have to give notice, and there's a couple of very tricky questions about judicial review, which I hope she'll get into, particularly in the context of the tort cases. That, of course, takes care of new rules by having agencies prospectively deal with this problem in a more thoughtful and careful way. What about existing rules? Well, we could say there's a clear statement requirement, but it's very hard to do that for existing rules. The courts might say, well, they could have expressed it clearly, and they didn't express it clearly, so there's no preemption. The trouble with that, of course, is it's true of every piece of statutory or rule construction you can imagine. If only they had said it clearly, we wouldn't have a lawsuit. As favorable as that might be in terms of outcomes for me, I don't think that's a very sensible way of analyzing the preemption provision. So short of absolute, I think the courts ought to exercise caution, and the agencies ought to exercise caution. They ought to think about the results, and they should not preempt state laws absent significant interference, not some theoretical interference, but some significant interference. If the agency tells you, metaphorically, to put your foot on the accelerator and the brake at the same time, companies have the right to say, pick one or the other, but don't make me do both. Finally, what about the courts? The one surprise, which doesn't appear on Michael's charts, is that by and large, the Supreme Court has been less favorable to preemption than the federal courts of appeals. Surprisingly so. Certainly in the earlier days, and even now today, the federal courts of appeals have been very pro-preemption side, and the Supreme Court has been, in my view, more balanced. The courts purport to follow congressional intent. My own view is that they would do better if they, instead of saying, what did Congress intend, because I don't think Congress intended much of anything, is to say, think about the statute and what would Congress have done about preemption if they had actually thought about it. Think about the tobacco cases. We're talking about 1965. Congress is coming in and going to create a new federal scheme on warnings on tobacco. Nobody in the tobacco industry had the temerity to ask Congress for a preemption exemption at the time, and just imagine what would have happened if they did. And yet, a few years later, they came in and they said, in essence, every one of your tort claims was wiped out by a law that was intended to protect smokers, even from fraud. Courts stepped back and said, clearly that's not what Congress meant at all. Similarly, I think they went wrong in the Medical Devices Act. Here was a statute that was enacted for the purpose of protecting consumers in an area which there had been no preemption before because there was no regulation. There was no alternative damages remedy, and the court came in and simply said, it's all wiped out as for new devices. Seems to me, without any substitute, that's a very difficult reason to understand. Now, if you acknowledge that there's some uncertainty, that it was not considered and it was not overcome by a few words, then what are you going to do? Well, there's a federal judge who shall remain nameless who once referred to what the Supreme Court is doing in this area as acting like a bunch of pettifogging grammarians. It may not be quite that bad, but the attempt to turn around a major issue like this on a word or the absence of a word when nobody thinks that Congress really thought about the topic, let alone the words it was using, seems to be absolutely wrong. And the court should step back and ask, does preemption make sense? Is it consistent with the purposes of the law? And if the agency comes before it, ask, when did the agency first say preemption? Was it when the case got to the court or back at the earlier time? It ought to be more skeptical of agencies when they come lately and less skeptical when they do it at the time of the initial regulation. So I'm not saying that there should be no preemption and that agencies are sometimes not right and the defendants are not sometimes right, but I'm very cautious that preemption is often far broader than it needs to be. Now, at this point is my takeaway. If the students were in the classroom, they'd get out their pads and pencils or get out their computers and stop playing court stenographer. I think we need a fresh start. It's not just the courts, but Congress and the administrative agencies. We have to think through preemption in a way that it hasn't thought through in the past. Thank you.
Thank you, Dean Morrison.